I do. I did file a motion in the lower court that was never addressed. Um, and I was just wondering how that exactly worked because the motion I applied for was dismissed.
That you representing yourself would not unduly disrupt or inconvenience of the court or hurt the process. And on a Samsung device, please unmute yourself and tell me your name.
Nathan James McElroy.
I've got you, Mr. McElroy. Thank you. I've also got another device that I'm trying to identify as well. On the Samsung device, sir.
Can you hear me now?
I can. Thank you. What's your name?
I am a flesh and blood man with a 945.
I don't really answer to flesh and blood men because I have to identify people on this court docket by a specific name. You're either identified by a specific name and you can be heard, or you're not going to be identified and I won't hear you. So you want to tell me your name, or do you want me to remove you from the hearing room and proceed in your absence?
My last name is Lasecki.
Mr. Lasecki, you're here for a final status conference. We have a trial set for you. You are Jeffrey Joseph Lasecki, correct?
Yes.
Mr. Lasecki, I'll be with you in just a moment. I'm going to put you in the waiting room, and as soon as I'm ready to call your case, I'll bring you back in. Thank you. A matter of people of the state of Michigan versus Jeffrey Joseph Lasecki. This is file number 24-4944FH.
Your Honor, Ryan Ziegler on behalf of the people.
Thank you. And Mr. Lasecki, we're back here on the record. As you know from our prior communications, one of the things I have a duty to do at each start of each hearing is to make sure you understand the circumstances, because you're still representing yourself. Is that right?
That is right.
So the requirements that I have under the Michigan court rules and statutes are that I have to make sure you have knowingly chosen to ask me to represent yourself. Have you made that choice clearly and in knowledge, with knowledge of the specific risks?
Clearly and knowledgeably.
And that's what I found before, Mr. Lasecki. And one of the other things that I made a specific finding regarding is, under the court rule, I have to make a finding that you representing yourself would not unduly disrupt or inconvenience of the court or hurt the process of justice from being completed. I made that finding clearly and articulately last time. I didn't have any issue whatsoever. I have a somewhat different view of the case now because of the interaction that we just had when I brought you in and asked you what I thought was a fairly innocuous question about identifying yourself. So now I know who I'm dealing with. Because if I make the determination that it's going to hinder the administration of justice with you representing yourself, that's a factor that I have to be aware of. So, Mr. Lasecki, if we have a jury trial where you're representing yourself, are you going to be problematic to where I'm not going to be able to get my job done?
No, sir, I will not.
Okay. Mr. Lasecki, I don't expect that there's going to be an overly formal process for a jury trial. It is a formal process, but I'm going to be willing to slow down, take the time that we need to make sure that you understand what's going on and that the prosecutor understands in the same vein. But I can't have the prosecutor slow down proceedings by the way he does things, and I can't have and won't have you do it either. So preliminarily, I make the finding that you're going to be able to represent yourself because it's clear to me that you've knowingly waived the right to have counsel. But I want to make sure you understand, again, you do have the right to an attorney's assistance, even if you couldn't afford one. And if you want a time to talk with an attorney, I would provide that time right now or at any time you ask it. Do you understand that?
I understand that.
All right. And I also need to make sure, again, that you're aware the offense that you're charged with, the police officer resist, obstruct, or oppose, that is a felony offense, and that means a maximum punishment of up to 2 years in the state prison system and or a fine of up to $2,000. You told me before you were clearly aware of those maximum penalties. Are you still aware of them?
I am aware.
Do you have any questions regarding any of that?
Regarding the charges itself, or is it, I'm asking.
Yeah, let's start with the charges. Do you have any questions about the nature of the charge, what it's alleging, or the maximum penalties?
My question is how can I be charged with resisting when I haven't been charged with any crime?
Well, the question is a good one, but it's a circumstance-driven offense. And so what I can't do is tell you what I don't know, and I don't know the specifics of this case in any way. I know the charge alone, Oftentimes that's confusing to members of the public, jurors, defendants, even sometimes to attorneys. But as a judge, I don't know anything about the facts of this case unless and until I decide an issue on a motion where an attorney argued the facts to me, or until I have a trial. So I don't know what the specific circumstances are. The prosecutor, though, has made allegations that you resisted and obstructed. In order to prove that, he has to prove that the police were lawfully there or that they were engaged in lawful performance of their duties. Mr. Ziegler, do you agree with the court's assessment of what your duty is to prove?
Yes, Your Honor.
Did you want to make a specific offer of proof?
Your Honor, we had a preliminary exam in this case.
All
So
right.
Mr. Lasecki is fully aware of what my offer of proof is going to be.
All right. And so any questions that you have, Mr. Lasecki, because I can't answer them, I don't know anything about the facts of this case, literally zero. You can phrase those questions if you have them to Mr. Ziegler if you want to. You don't have any duty to talk to him, but he's the prosecutor and you're representing yourself. If you were represented by counsel, your counsel would constantly be in communications with the prosecutor regarding the theories of the case. Again, you're entitled to do that. You're not required to. Do you have any other questions about the background of the case?
I have one question for you. How did the prosecutor inform me and let me know of that? I've never talked to him one time.
Well, the prosecutor lets you know and informs you of the allegations against you by filing first what's called a complaint. A complaint is what alleges the criminal offense, and after a preliminary examination, which apparently was held, that transforms into what's called an information. An information is what's the criminal document that charges you with a felony offense. So he's informed you of those allegations by that written document, which is entitled information. A copy that's in the court file. If you want to inspect it or get a copy of it, you're entitled to. But that's how the prosecutor informs you of those allegations.
Okay, is that something that I have to take upon myself voluntarily? Because
No, it's
I
gotta
don't,
be
I don't
provided.
want to. I'm sorry, sir. Go ahead.
It's got to be provided to you.
Okay, and when has that been provided to me?
It would have been provided to you immediately, generally, upon the bind over, after the bind over from the preliminary examination. Did you want to speak to that, Mr. Ziegler?
In terms of providing information, Your Honor, I believe I handed it to him on the record at the time of the bind over.
All right. And that's typically how it happens, Mr. Lasecki, is immediately after a bind over, which is a transfer between district court and circuit court. There's then an arraignment on the information is what we call it. And an arraignment on the information is where the prosecutor physically hands that charging document to you. And then you have a right to be heard on it, plead not guilty, stand mute, plead guilty, or take any other action that you ask. But that would have all happened, generally speaking, in the district court. Again, I wasn't present in the district court. Obviously, I don't know what happened.
Okay, I can say that I did go to his office. He did hand me that piece of paper. I went to his office and his court clerk or whatever she may be, she told me to disregard.
Well, I'm not sure what you're suggesting. I, again, wasn't there, so I can't rule upon anything that I wasn't personally aware of or that's not been brought to me. If you have issues or questions about the background of the case that you think are subject to legal determinations, you, like any party, can file a written motion. And a written motion is a motion. It's a suggestion in writing that I should make some sort of an order. You would have to cite what you think I should do, why you think I should do it, and the law that would conform that I would be able to do what you're asking me to do. I will provide you time to file those motions if you have them. Is that what you're suggesting? Is that you want to file some sort of a written motion with the court?
Yes, sir.
So the difficulty for you is this, and it's not particularly difficult, but the difficulty is timing. My office is extremely busy because I'm a circuit court judge in 3 different counties. So I'm in Kalkaska only about a week per month.
Okay.
What that means is I only have the time to hear matters of importance in this county relatively infrequently. And as you know, we've got a trial date set for you right now. And that trial date is coming up later this month. It's on the 12th. So it's coming up very soon. It's only 8 days from right now. You were obviously aware of the trial date, correct?
Yes.
And you have a right to a trial. And if you want to have the trial on the 12th, we'll have it. I want to hear from the prosecutor on that in terms of his readiness as well. But if I gave you time to file a motion, it necessarily is going to mean we're not going to be able to have your trial on the 12th. because there's no time for you to file that motion, for the prosecutor to be able to receive it and respond to it, and then ultimately for me to have a hearing and make a decision on it. You understand?
I do. I did file a motion in the lower court that was never addressed. And I was just wondering how that exactly worked because the motion I applied for was dismissal and I never heard anything of it.
Well, I'm not going to speak to what I'm not aware of, but here's what I will tell you. You have a right to file motions in this court. If you file motions in any other court, I'm not going to be aware of it. I can't possibly respond to it. If you want to file a motion in this, I'll give you time to do it, and then I'll make a ruling on it before we have a trial.
Okay, I will get that motion to you within the next 2 days. I will hand deliver it.
All right, so what you need to do though, to be more clear, it's somewhat confusing in the 46th Circuit because I am in 3 different counties. So if you file a motion, you need to file it initially, the first copy, the original with the clerk's office. That's next door to here in Kalkaska County. You're then required to serve a copy of that same motion on the prosecutor's office. And then you're required under the court rules to send what's called a judge's copy to me. So it's just a copy of the motion, but you've got to send it to me at my address in Grayling. So I can give you that address, but that's where my primary office is. That's where you need to send my copy of the motion. What you need to do additionally is if you're going to file that motion, I'll give you my staff's phone number because my staff has to set aside time for a hearing. And that you'll have to call her, you'll have to get that date, and then you'll have to provide that in what's called a notice of hearing. That's where you tell us that you're going to be having your motion heard. You make sure the prosecutor is aware of it so that he can respond, and then you make sure I get a copy of it.
Okay.
So it looks like you're going to get a piece of paper or something to write this down.
Yes, sir.
Okay, let me know when you have a piece of paper.
Okay, I do have a piece of paper, and I do have your address in Grayling, and that is
Okay,
where
well,
I will hand deliver.
Okay, and that's fine. You're welcome to hand deliver it to the office there. It's 200 West Michigan Avenue in Grayling. The phone number for my staff, though, you'll also have to get a hearing date. The phone number for my staff is 989. Date and a time for that hearing to be held, and then you'll have to provide that notice of hearing. That notice of hearing, again, same process, gets filed with the clerk's office, a copy to Mr. Ziegler, a copy to my office. Then he'll have the opportunity to respond in writing as well. Did you get that phone number?
Yes, I did.
That's right. And so again, you want me to give you that time to file your motion and have that heard before you have a trial?
Yes, if you would, please.
Mr. Ziegler, as to that point, my staff received communication from you that you had an issue with getting the trial notice, but I think you still submitted jury instructions. So are you ready to proceed to trial if I decided to proceed to trial?
Your Honor, that's correct. We had not received the notice of the trial. I didn't know about it until I saw that it was listed on the docket today for a trial the following week. But it's a relatively simple case. I did file the jury instructions. I was planning on handing Mr. Lasecki a copy today, but I'll put those in the mail. I have not filed a witness and exhibit list yet, but I could be prepared to proceed on Thursday if the court so wished to proceed. It's not a complicated case.
Well, given that the defense wants time to seek to file a motion that potentially is dispositive, do the people have an objection to me deciding a dispositive motion before trial?
I have no objection to the court adjourning trial to allow the defendant to file his motions, Your Honor.
All right. And again, I always ask the prosecutor, Mr. Lasecki, because it's not only you that has a right to a prompt and speedy trial, but also the prosecutor. But if it's a dispositive issue, meaning if it would potentially resolve the case, it needs to be filed and needs to be heard by me before we have a trial. So I'm going to adjourn the trial. How long out should I set the trial, Mr. Lasecki? Should I just wait and address you and Mr. Ziegler at the motion hearing? Obviously, if I dismiss the case, it'll be done. If I don't, then we can pick a trial date.
That sounds good.
Any objection to that?
Sure, Your Honor, I think that's appropriate.
All right, so I'll have a status conference just noticed up for the same time as your motion hearing. Again, do you have any questions about the process of getting that hearing date, the notice of hearing? Who needs to give a copy to any of that, Mr. Lasecki?
Can you tell me one more time who I need to give a copy to?
Yes, so the original, your first copy will go to the clerk's office. Then you need to get a copy to the prosecutor's office, and then you need to get a copy to me, the judge's copy. So everything that you file with the court always needs to be in that fashion. That way, Mr. Ziegler knows what you're providing to me. The clerk office has a copy for the court file, and then obviously I've got my copy so that I can be prepared to make a ruling.
Okay, thank you.
All right, Mr. Ziegler, anything further on this case today?
No, Your Honor.
Okay, Mr. Lisecki, we'll see you at your status conference and the motion hearing. Just make sure and get all of that filed, and we'll see you at that time.
Okay, God bless. Thank you.
Thank you.